but I think he'd be willing to negotiate if it was a good position. Hello and welcome to Media Reporter. My name is Nicole Israel. Thanks for joining us today. And with us, we're very excited to have Anna Carley from the Carley Law offices that practice in New Jersey and New York. Thank you for being here.
Thank you for inviting me. It's my pleasure.
And we're going to talk about some very hot topics today. Firstly, including divorce and about prenups and postnups and the complexities and myths surrounding them. So I guess first, if we could start with, how can married people protect themselves in case of divorce?
If you're not married yet and you're thinking about getting married, one way of planning to protect your assets or maybe have your partner be protected in the relationship is by, drafting a prenup. And usually people think it could be something that kills the romance or otherwise negatively affects a relationship and may even break a great engagement. But in my experience as an attorney, it hasn't been the case. This is a prenup usually is a way of financial planning for the future for heterosexual and homosexual couples alike. As we know, New York nowadays allows gay marriage and we're all happy about it. And prenups are an instrument, a legal instrument that will help couples deal with situations when it comes to divorce or separation and allow division of assets pursuant to a couple's desire. Usually, when it comes to gay future spouses, there could be problems of accepting the prenup. For instance, if a couple gets married in a state that allows gay marriage and accepts them as a married couple, for instance, like New York or Connecticut in that case, there's no problem. But if a couple moves away to another state and then marital problems arise in their relationship and they decide to get divorced, it is possible that those contracts will not be accepted or will not be deemed valid in the state where they decide to reside if that state does not accept gay marriage and does not have a gay marriage law on the books. And that's because of the law that was actually passed during Bill Clinton's times in 1996, and it's called DOMA for short. And what it does, it effectively protects a marriage as being between a man and a woman. And it says that any federal benefits, such as tax breaks, filing the taxes jointly, you get a little bit of a break, do not apply to spouses that are of the same sex. And that's federal law that interferes with a lot of state laws that do allow a gay marriage and give full benefits to couples that are of the same sex. And actually, I have a client in New Jersey who just decided to get divorced, unfortunately, and a judge ordered that she pay alimony pursuant to the prenup that we drafted for her. However, she did not get a tax break because usually a paying spouse would get some kind of a tax break, and in her case it would be estimated at about $12,000 a year for paying alimony, and she did not get that at the same time.
And if you could talk about some of the, there are so many myths surrounding prenups, how it's unromantic or it's not for younger people who are getting married. Can you kind of break those myths?
Absolutely. We have so many clients coming through our office doors saying, I would like to have a prenup, I have some assets, I would like to protect my assets, or have my spouse rather, feel that if she stays at home with children, she's not missing out and she's going to be taken care of down the line better than the law provides. Therefore, I try to convince my clients that usually it's not the case that drafting a prenup would be something that's unromantic, and this is one of the first myths that I would like to debunk. Unromantic meaning it does not tell, having a prenup does not tell you that I don't love you or I don't want to be with you. It's basically a blanket of security that provides and delineates terms for in case of breakup, and it keeps people more secure probably in the future. Also, another myth, for instance, it would be that the young people don't need a prenup. But as we know, in case of Mark Zuckerberg, the prenup was necessary. That prenup had all kinds of different provisions. However, we know that not every young couple has $17 billion in the bank, but nonetheless, nowadays a lot of couples get married later, and the statistics say that women get married at around 26 on average, 26 years old, and men get married when they turn 28 or older. Therefore, by that time, they have already amassed a lot of assets, probably a car or 401k, or they have something in their investment account. Therefore, a lot of young people nowadays could benefit from having a prenup, and it would serve them well. And at the same time, a lot of young people who haven't amassed assets have degrees, college degrees, and so on, that we probably would like to protect. And also, a prenup can tell you who is responsible for college debt if one of the spouses is going to pay for or support you through school, and in the future you decide to separate.
What about the myth that prenups are bad for women?
Oh, that's absolutely not true, because a lot of times prenups put women on equal ground with their spouses. If those women decide to stay at home and raise children, or take a part-time job instead of a full-time job, and feel like they miss out on their career. So in that way, a prenup can give a woman better terms in case there's a divorce than what the law would provide for her.
And prenups aren't going to cause a divorce. This needs to be talked out, I guess, before you actually work it out.
Usually, prenups are never a cause of a divorce, and it should be noted that a prenup, as a contract itself, it allows the spouses to show all the financial assets and bring out all the necessary questions and answer questions about debts and other things that just the full disclosure allows. So having a prenup and having full financial disclosure is very important for a relationship in terms of honesty and openness.
Now, what if a couple gets married and they don't have a prenup? Is there anything they could do to protect themselves after the fact?
Oh, absolutely. There's such a thing as a postnuptial agreement. Those agreements are usually enforceable. They're defined as agreements created after marriage, and those agreements either fundamentally cement the law that provides the spouse for the spouse in terms of divorce, or for both spouses, or they change that law in some terms and maybe make it better or worse. But pursuant to that, if parties agree and they're fine with that, postnuptial agreement is also another tool of that allows parties to divide assets in the future, whatever they amass during marriage, and so on. So,
are there any, I guess, more fundamental differences between the prenup and postnup?
Yes, a prenup has to be drafted prior to marriage, and a marriage has to occur for a prenup to actually take effect, and a postnuptial agreement is usually drafted after parties got married, and the American Law Association defines a postnuptial agreement or a marital agreement as an agreement between parties after the marriage. And American Law Association applies the same definition to the agreement between heterosexual and homosexual spouses.
Okay, and they're enforceable. It's a
Absolutely. Those agreements are enforceable if they're in writing, and that's one of the requirements in almost all of the states in the United States. They also have to comply with all the requirements for a contract, such as, for instance, offer, acceptance, consideration, lack of duress or undue influence, and so on. There's also a law in New York that imposes some requirements for a postnuptial agreement to be enforceable. It has to be in writing, and the DRL 236 provides that not only does it have to be in writing, it also has to be notarized or acknowledged. It has to be mutual assent of the parties. It has to be without duress, meaning the parties have to agree, and full and fair financial disclosure has to occur, which is similar law is on the books in the state of Connecticut, our neighboring state, and the state of New Jersey. Mm-hmm. So most of the time, the requirements are the same as in the contract, but more stringent in terms of notarization and acknowledgement is required, and fairness is absolutely required in those cases. Okay.
Now another, I guess you also kind of mentioned some of the, for prenups, especially celebrity prenups. Yes. Prenups are not just for celebrities, and you have some quirky, I guess, anecdotes from some of the celebrity prenups. I guess so you can put different, it doesn't have to be certain assets, but you could do it unique to your own situation.
Yes, every prenup can be modified, and as we can tell, there are all kinds of different provisions that could be put in an agreement, such as a prenup or a postnup. And we hear about a lot of funny provisions, such as in the marriage of Khloe Kardashian, where she asked for Lakers tickets. Even if they get divorced, can you imagine her wanting to watch her ex-husband play? Also, there's another one, Mark Zuckerberg, as I mentioned. They have a provision, as the rumor has it, of having 100 minutes away from the office and from the flat for Mark Zuckerberg, meaning to spend time together, and also required one date a week, as it is my understanding. There's also another provision that probably did not occur, but Jessica Simpson, when she was dating one of her ex-beaux, had a little bit of a prenup rumor that if she were to gain 135 pounds or more, then, or weigh rather 135 pounds, mm-hmm. she would have to pay that person about $500,000. So there's also Charlie Sheen, and his prenuptial agreement, we know that he had a provision that said that if he were to ever cheat on his wife, he would have to pay her $4 million, which is another big one.
Okay, now just stepping away from prenups and postnups is another big issue dealing with gay marriage and divorce. Now this issue might be going to the Supreme Court, whether or not they're going to decide on it. If you could clarify some of the questions many people have, including if homosexual couples who are legally married under state law, are they entitled to the same benefits under federal law? And I know you touched on this earlier, but if you could elaborate more on that.
Absolutely. On October 1st, a lot of supporters of gay marriage came out, and they were really hoping that the Supreme Court would take up this issue of allowing homosexual couples to take advantage of the federal perks or federal benefits. And now there are about 1,000 of them that heterosexual couples have been, taken advantage of for a long time, or, being under protection of those perks. And nowadays, it's a very important issue, since we have in about 8 states gay marriage is allowed, and about 12 states allow partnership or union, gay union or partnerships, and they're legal. And New Jersey basically gives similar rights and protections for their gay union couples as a regular married couple would have. So it's a very similar situation. However, a lot of times gay spouses are not able to either inherit or take the benefit of 401k or inherit some other things that would be under federal law regulated. So therefore, it's a big issue, and we were hoping that the Supreme Court would take it up. However, it did not happen, and there was hopes that the Supreme Court would talk about it during their September meeting, which is a private meeting that did not happen as well. And now we're thinking that probably this issue will be taken up by the Supreme Court in November after the elections, and that means that the hearing will take place sometime in the spring. So one of the cases, very famous case, is the case of Gill is the last name of a woman who was trying to get benefits, federal benefits, as a gay spouse, and this case is probably going to be heard because it was filed for an appeal in the summer. But a lot of issues arise out of intestacy statutes. What is an intestacy statute is a statute that protects or provides for distribution of assets of a deceased person, which, you know, if you don't have a will, then that statute would apply. And in many states, those statutes don't apply to homosexual spouses because in their definition, a spouse is not regarded as the same-sex spouse. A spouse is defined as a man or a woman, and a relationship is only defined as between heterosexual, a male or female. Therefore, if somebody were to die and they're same-sex couple, one of their spouse or their partner would not inherit under the statute, and if there's no will, then there is no distribution, obviously, to that person. And by distribution, I mean distribution of assets. And our firm would actually help to avoid this problem by drafting wills or providing for some other legal protection for people who think that this would be an issue, and the legal assessment is made every time a client comes in. In New York, however, there's a Marriage Equality Act that was passed, and this situation would not arise because in New York equalizes definition of spouse and equally applies spouse definition to heterosexual and homosexual couple. So that's helpful. But even before that act, a lot of surrogates courts were deciding that same-sex partners distributees under the Intestacy Statute, meaning that they are allowed to inherit even if there's no will. And but otherwise, you know, some other surrogate courts would decide and go the other way. Therefore, the Marriage Equality Act definitely helped in the state of New York. And those issues arise in many different states. And as I mentioned before, if a couple is married in a state that allows gay marriage but moves to a different state that does not allow gay marriage or a union, the problem of divorce or inheritance may definitely arise if there is no will, and prenup may not be enforceable, or postnup, for that matter, may not be enforceable in that state. Therefore, it's very important that the Supreme Court takes up the issue of federal benefits and gay marriage. However, we do not anticipate that the Supreme Court will take up the issue of gay marriage, and I think they will stick to the more narrow issue of federal benefits being applicable to same-sex spouses or same-sex couples.
So if they did that, that would help resolve the issue if gay marriage a couple is married in a state that provides for gay marriage and goes to one that doesn't. This would kind of rectify. Definitely. Everything.
Whereas now we have to either advise our clients not to move to a certain state. For instance, Connecticut allows for gay marriage, so if one were to move from New York to Connecticut, there would be no issue. However, there are other states that don't. And then in a particular situation of every client, we would ask if there is a desire to move, then we would ask what the state would be, and then we would provide an assessment of what kind of issues they should expect.
And is that one of the more pressing issues you see as clients come into your office?
Absolutely. I believe that, of course, the prenuptial and postnuptial agreements and asset protection is something that everybody is concerned about, even if they believe in one of the myths and do not want to upset their other future spouse, even though sometimes if you just explain that it could be that a prenup could be for the benefit of the both spouses and makes it much easier. The upsetness factor does not come into play at all. But it's a very important issue, and a lot of clients come in asking about that as well.
And so how do you advise them if they do seek out a prenup and they want to get married in a state that for gay marriage?
Usually we have many background questions that we ask our potential clients. Since it's important to ascertain what their needs are, and sometimes people coming in, they have a great idea of what they would like, but also there could be some nuances that may be missed if we don't ask certain questions to obtain a full picture of their situation. And then we give them an advice as to what kind of prenuptial agreement or postnuptial agreement would be work best in their situation, depending on what they would like to protect, or if they would like to equalize the relationship between a moneyed spouse and a non-moneyed spouse, which is one of the terms that is used.
Okay. And so in your opinion, though, just lastly, going forward, how do you view the Supreme Court kind of forming their decision on gay marriage?
It's very interesting. It's a very interesting question, and I think that a lot of judges nowadays are not going to be willing to support gay marriage as being something universally acceptable in this country. However, in other countries, that's been the case, and gay marriage is legal. But hopefully, with years and sometime soon, we believe that gay marriage may become something accepted on federal level and state level, so that there is no discrepancy in laws, and because it does make life of homosexual couple much more difficult. Even if they feel that a marriage is accepted on the state level, it may not be accepted on the federal level, and it definitely causes a lot of anguish in relationships and in society as well. And I do hope, and by our firm, we do hope that our legislature as well as Supreme Court judges recognize that this issue is becoming more and more pressing.
Okay, and you see that with, it sounds like half the states do honor gay marriage and honor civil unions, while the rest of the states do not. Do you see an influx of people from the states that do not making the move to states that do? Is that just universal?
I think, I just wanted to point out, even if some of the states allow civil unions or partnerships per se, the benefits or the benefits that are provided for those same-sex couples vary state to state. Like I said, New Jersey almost makes or provides equal benefits to same-sex couples. However, some other states may not give them such an amount of benefits, and so that is also another issue. And I believe that it probably affects where gay couples decide to stay or decide to move. However, the job market obviously nowadays is also a very important factor to consider in terms of selecting where to live.
Absolutely. And have you seen, just going back to divorce though, with the economy as it is, do you see an increase or a decrease in divorce so people don't want to spend the money to, have the legal factors come into play and they decide to stay together even if they don't get along?
Well, as we know, the divorce rate across the country is up. It comes up to about 50%, more or less, depending on the year. Divorces are up during depressions or unstable economic times, and economic problems in the family are one of the #1 causes for divorce, and that's the case. So yes, we definitely see that financial aspects of the relationship do affect people's decisions about whether to stay married or get divorced. However, hopefully that's not going to be the case in the future, and as we all hope that the economy will get better. And also, and the relationship side of it is very important, and therefore a prenuptial or postnuptial agreement may definitely provide a cushion or security for a spouse that does not wish to stay married, if certain terms are included in those prenuptial or postnuptial agreements.
So if a couple decided to get divorced, would they still be applicable for a postnup agreement once the decision for divorce was made?
In that case, I would advise them to make a separation agreement that will work for the both of them, because a postnuptial agreement has to be voluntary, has to be not under duress, and sometimes a desire to get divorced and the pressure from a spouse who would like to get divorced may not be something that will make a postnuptial agreement in those circumstances equitable or enforceable. Therefore, I believe that a separation agreement or a divorce settlement agreement would be best in that situation. However, any couple that's thinking about getting divorced should get an advice from an experienced attorney and make their decision based on information they receive from their attorney.
Okay, and just also lastly, under what circumstances should a couple definitely decide to seek out divorce?
I believe that it's a personal decision that every couple makes. However, and I am not the proponent of divorce in under no circumstances, and therefore I believe that a prenuptial agreement or a postnuptial agreement are pivotal, so that the couples know what awaits them when the hard times come in terms of relationship, rocky relationship. But I believe that it's definitely a personal decision that every couple should make.
Okay, great. Thank you so much for being
here, Thank you for having
Anna.
me. It was my pleasure, and the topics are very important. As you know, they're so pressing, and hopefully the Supreme Court will figure it out.
Hopefully.
Yes.
Thank you. It's Anna Carley from Carley Law Offices that do practice in New Jersey and New York. And thank you for watching this edition of Media Reporter. I'm Nicole Israel. Have a good evening. Well, you did.